badly needed in this crucial time when the world as we know it has wobbled badly due to a virus, and the nation is in turmoil with so many people asking, is the judiciary fulfilling its role as Sentinel or the Qui Vive? Our trustee and former election commissioner, Mr. T.S. Krishnamurthy, has so kindly agreed to preside over today's program. I would like to thank him for persuading Justice Venkatachaliah to accept our invitation. We are grateful to Madam Indira Jaising and Justice A K Sikri for their willingness to add heft and luster to today's program with their formidable experience at the bar and the bench. A word about Moneylife Foundation's RTI Center. We work at educating and empowering people to use the RTI Act effectively. We're able to do this due to the support and participation of some of India's best known and most dedicated RTI activists. I'm delighted that so many of them are here today. The RTI Center was established because of the gracious support of Mr. Dinesh Thakur, who's also here with us today from the US, who's globally renowned as the whistleblower who exposed Ranbaxy's dubious testing methods. His foundation supports a host of healthcare and RTI initiatives in India. A big thank you to our media partners, Free Press Journal, Bar and Bench, and The Leaflet for being our partners at today's program. Before I invite Mr. Krishnamurthy to take over today's program, some quick ground rules. Except our speakers, everybody else will be in mute. For best viewing, we recommend you put yourself in active speaker mode. You can use the chat facility to communicate with us during the session. If you click the red raised hand button, we know you have a question. This will be during the discussion that follows. And this program is recorded. It will be available on Moneylife's YouTube channel. It's also being live streamed on Facebook. If you want to protect your privacy, we suggest you turn off your video at home so that your background is not visible to everybody. I now have the honor and the pleasure of handing over this program to Mr. Krishnamurthy. Mr. Krishnamurthy, you're on mute.
Sir, I think you're on mute. You might have to unmute yourself.
Yeah, I know. I'm trying. Now I've got it unmuted. Are you able to hear me?
Yeah, yes, sir. Yes, sir.
Yeah. Very good evening to all of you. First of all, let me thank Mr. Justice Venkatachaliah for being with us. It's a pleasure and a privilege to be associated with him. I have known him from year 2000 when I was in the secretary in the Department of Company Affairs. His contribution to the strengthening of the quality of judiciary in this country cannot be overemphasized, and his nation's pride, that's what I always say. And I'm glad that he has accepted our request to give this third RTA lecture for the Moneylife Foundation. He is a true believer in judicial accountability. He has often said that judiciary should be subject to any criticism and should be able to face them and make the judges should be more accountable to the public. The way in which he conducted himself, not only in the Supreme Court but also thereafter in the Human Rights Commission, it's all very well appreciated. He's not only brilliant, age is not withered his brilliance, yet nor custom style his infinite variety or talents. He is keeping himself updated with latest developments in every field, not only in judiciary, but in other areas. It has always been a pleasure to hear him. I am glad that he accepted this invitation to give this lecture. He has been awarded with many national honors, including Padma Vibhushan. But what is more important is his humility. I have never seen a person more humble than Mr. Justice Venkatachaliah, in spite of his not only his integrity and his knowledge, but also his remarkable interpersonal relationship. We are grateful to you, sir, for being with us today, and we are looking forward to your lecture. Thank you very much. And of course, I would like to add Justice Sikri and Mrs. Indira Jaising, who have also been in the panel discussion. They will be separately introduced, but we are happy that they are part of today's function. Thank you very much.
We now start Justice Venkatachaliah's lecture. May I invite him to speak, please? announcement.
Just 1 second. I think we're just checking the audio. Just 1 second. We'll just check the audio. Yes, ma'am.
Esteemed Sri Krishnamurti ji, Mas Sucheta Dalal, ladies and gentlemen, I am deeply sensible of the honor of this invitation. The RTI lectures of the Moneylife Foundation have acquired a high reputation. The galaxy of earlier speakers is intellectually intimidating. I'm here because I could not disobey my esteemed friend, Sri T.S. Krishnamurti ji, who has a splendid record both as an acclaimed administrator and as the Chief Election Commissioner of the nation. When the first controlled nuclear fission was achieved at Los Alamos, Albert Einstein exhorted, everything changed. The world has to adopt a different line of thinking if it is to survive. In the COVID world, everything has changed again. COVID pandemic has changed everything. What will the post-COVID world be like? The leaders of the world must sit down, take a deep breath, and formulate what the post-COVID world needs. A broad sense of humanism and human welfare and human survival must inform that debate. Imagine a world where just 4 richest persons own wealth equivalent to 4 billion poor of the world. Our country is a beautiful land with breathtaking scenic beauty, great mountains, rivers, lakes, ocean, and a large share of the flowering plants of the world, and an equable weather, 12 hours of night and 12 hours a day, the envy of many of the northern states. Human life can be happy if only those who preside over their destiny can let it happen. People must be emancipated from the curse of corruption and inefficiency. In the next 45 minutes or so, I propose to share with you, or rather place before you, some thoughts of a 92-year-old extinguished judge on what Indian judiciary has done to promote what the Indian judiciary has done to promote the egalitarian philosophy of the Constitution, to protect individual liberty, and the philosophy of legal control of government. The expression Qui Vive was first introduced into the constitutional parlance by Justice Patanjali Shastri in the famous case of V.G. Rao back in the year 1952. It expresses the constitutional philosophy of checks and balances. It simply means this: the structure of government should be so designed that each branch is a sentinel on the Qui Vive against the other two, lest they become too powerful or too autocratic. No constitution works by itself. It needs the instruments of the common law, legislation, and constitutional conventions. That's a very, very important thing. There is symbolism in constitutional expressions. For instance, Article 53(1) of the Constitution proclaims that the executive power of the Union shall be vested in the President and shall be exercised by him either directly or through officers subordinate to him in accordance with the Constitution. This is an impressive statement. It has just one defect in it, literally understood. The position is exactly the opposite of what it conveys. The President, except in some special situations, must act only on the advice of his Council of Ministers. Inviting the leader of the Parliament to form the government may be one exception. Rashtrapati Bhavan is not, to borrow the expression of Justice Krishna, Rashtrapati Bhavan is not a halfway house between the White House and the Buckingham Palace. This is not the Potomac, but the Thames that fertilizes the flow of the Yamuna. On this issue of the power of the President, there are some serious arguments and differences between the then President, Dr. Rajendra Prasad, and Prime Minister Nehru. Dr. Rajendra Prasad said he is not the British Queen, but an elected Indian President. Supreme Court later had to laid this argument to rest. The interrogative title of this talk has a veiled, though not explicit message that the judicial wing of the state might not be doing enough. The judiciary in the classical mold of an adversarial system is just an umpire, as in the game of cricket. It still is, but great changes have occurred within the system. It is the advent of the public law principles that has changed the system and changed the judge from the position of a mere umpire into something more important and more significant. It is the advent of the public law principles that has brought about this change. A feudal society is grimly struggling to break away from the shackles of a tyrannical feudal social order and transforming itself and reborn into a modern egalitarian industrial society. Making of the Indian Constitution was an inspiring historic spiritual event. It was not a mere political event. That was at the end of the World War II, in which barbarous inhumanity and cruelty was exhibited. India's partition itself witnessed killings on an enormous scale on communal differences. In this context, the debates in the Constituent Assembly rose to spiritual heights in its concern to lay future foundation for a new social order based on respect for human life and to save the posterity from the scourge of communalism. The great diversities had to be accommodated. Imagine even the right of a person professing the Sikh faith to carry a kripan had to be expressly accommodated in the constitutional document. Even so, it was the genius of great judges to develop and nurture new judicial philosophy to aid the constitutional vision of a new egalitarian order and shape the architecture of an inclusive society. In this endeavor, the role of the Constitutional Court came to the forefront. Traditional threshold limitations on the entry to the courtroom had to be relaxed. We call it the locus standi. If a person did not have a direct personal interest in the subject matter of the litigation, he would be termed a mere meddlesome interloper or a busybody. But the poor and the marginalized whose interests were affected had no educational or financial means to access justice by themselves. Therefore, the threshold bar or locus standi had to be relaxed. That was done by a great act of judicial statesmanship. The second equally important transformation was of the role of the judge himself, no longer a mere umpire. He assumed the conceptual role of one who, quoting Upendra Bakshi, I say, who firmly anchors adjudicative leadership of the nation as an integral judicial duty towards the people of India and reinstall the concept of judicial power as an aspect of judicial duty. This is the most important transformation of the role perception of the judge in public law. Thirdly, the court had to fashion new tools for legal control of government. Every action of government had to have a legal pedigree. Court successfully enlarged the concept of state to include its instrumentalities and agencies, developing new legal algorithms for holding them down to the duties and responsibilities toward the people. Protect and promote democracy and democratic traditions, protect the environment, protect the vulnerable sections, women, children, prisoners, under trials, develop principles guiding the liability of those who store and use intrinsically dangerous substances, such as poisonous gas, etc., and develop absolute and not mere strict liability principles. All these are fascinating stories. We shall now get a short glimpse of them. Ladies and gentlemen, the public law administration lawyers and the areas they chose assisted the court to develop new instruments of legal control of government, principles of constitutional morality, and doctrine of manifest arbitration are some of these ideas developed by the court. But in actual working, they may present some difficulties and problems. They just do make law. The photographic theory, as it is called, of the judicial function, that a judge is merely to find the law as it is, and the lawmaking function does not belong to him. In the final analysis, is not a tenable theory. The nature of the judicial process itself is creative of the law. Doctrine of precedent makes it one judgment, one swallow will make the summer, and it will rule the roost in the next cases. There was never more sterile debate, said Lord Reed, that judges don't make law. Judges do make law. And he said, we do not believe in fairy tales anymore. Particularly impressive is the activism in the area of environmental protection, rehabilitation of the Doon Valley. Actually, after the mining there, it was a devastation. But the new rehabilitated Doon Valley is as flush, or perhaps more flush, more lush than what it was before. The Doon Valley, Aravalli Range are just some instances. The public interest litigation, epistolary jurisdiction, and the innovation of the appointment of commissioners and amicus curiae are extraordinary exploits of a new judicial era. As Sentinel, there are great cases that illustrate the chained role of the court as Sentinel, as the Qui Vive, Keshwananda, Satwant Singh, the passport case, Bandhua Mukti Morcha, where they expanded the locus standi, Banwasi Seva Ashram, Ajay Hasya, Airport Authority, Royappa, Sunil Batra, Bachan Singh, Idiga Annamma, Neelabati Behera, Husainara Khatun, Vishaka, in Kerala Education Bill, Joginder Kumar, D.K. Basu, Nandini Satpathy, Kamsi Mehta, Maneka Gandhi, Motilal Padampat, Olga Tellis, and many, many others which have blazed this trail. Vishaka case raised an interesting question of far-reaching significance as to what extent international covenants can be read into domestic laws. Ladies and gentlemen, most important transformation that came imperceptibly like twilight opening into daylight. The individual the adversarial legal system transformed itself into an inquisitorial system in public law. This is one of the most important changes in the philosophy of the judiciary itself. This is the cornerstone for all the other judicial exploits in the field of the role of the court as sentinel, the Qui Vive of the constitutional values. India is an ancient, and some critics say that India is an ancient, great civilization in an advanced state of decay. They say it lives concurrently in several centuries, both past, present, and future. But there's no denying the grandeur of its legacy, both culturally and politically. Ancient India was studded with republics, from Emperor Ashoka to Mahatma Gandhi. The recurrent theme of society was the celebration of human dignity and humanity, and celebration of the conscience of mankind. Long ago, someone described India as a functioning anarchy. The Global Competitiveness Report said that India is third in the world in the matter of availability of scientific talent, fourth in the world in the size of its domestic market, and fifth in the world in its potential to access international markets. But in India's overall competitiveness was placed at 50. But it's true that India is in the forefront of nations achieving economic breakthrough, not by exhausting their natural resources or by the raw muscle power of the factory, but by the brain power as a catalyst of progress. When India declared universal adult franchise and parliamentary democracy at the advent of its independence, the Western press was cynical about its success. They said, how can 330 million ignorant, uneducated people manage a government of Westminster model with such sophistication? It was called the biggest gamble in history. But the same press, 60 years later, in 2007, called the Indian democracy robust, though described as the rowdiest democracy. The origin of political democracy dates back to the 18th century, where it took roots as a form of governance in Great Britain. In 1865, a liberal statesman, John Bright, in his speech to support the electoral reform in England, called England the mother of all parliaments. This term was coined owing to the adoption of the Westminster model of parliamentary democracy by many countries of the former British Empire. Since then, the concept of parliamentary democracy has spread across many nations through ages. The need for social organization of man, stems from the fact that all human beings, incomplete in themselves, seek the ordainment of their destiny and their fulfillment in the enriching atmosphere of human companionship and political institutions. Democracy provides the richest and the most profound opportunities for this mutual enrichment. It is intended to provide the best opportunity for each member of the political society to achieve and bring out the best in him. Democracy is not the best form of government, but it is the least hostile amongst all the systems tried so far. When somebody said that in a democracy, people get the government they deserve, Bernard Shaw embellished it by saying that democracy is a system that ensures that people don't get a better government than they deserve. John Stuart Mill points out, I earlier said, that man's capacity for justice, according to Reinhold Niebuhr, makes democracy possible, but man's inclination to injustice makes democracy necessary. John Stuart Mill points out, the first element of good government, therefore, being the virtue and intelligence of the human beings composing the community. The most important point of excellence which any form of government can possess is to promote the virtue and intelligence of the people themselves. In the unforgettable words of Justice Frankfurter, democracy involves hardship of the unceasing responsibility of every citizen. That's why no office in the land is more important than that of being a citizen. The protection of democratic values in the conscience of the civil society, which should control the political society. Civil society must control the political society. If the civil society itself is fractured and fragmented and consists of groups in perpetual conflict with each other, then the political society will have ample opportunity to manipulate the groups and set up one against the other. Constitutional democracy is one where the majority will and rule is controlled and directed by constitutional principles. For otherwise, it will sooner or later degenerate into elective despotism and then mobocracy. Without constitutionalism, only the husk of democracy remains, and democracy becomes a mere statistical interpretation of numbers. Dr. Ambedkar, it's a very important statement that he made. Dr. Ambedkar, speaking in the Constitutional Assembly, referred to Grote, the historian, Greek historian. The diffusion of constitutional morality, not merely among the majority of the community, but throughout the whole, is the indispensable condition of a government at once free and peaceable. By constitutional morality, Grote meant a paramount reverence for the forms of the Constitution, enforcing obedience to the authority acting under and within those forms, yet combined with the habit of open speech, of action subject only to definite legal control. Dr. Ambedkar went on to say that this is a very, very important point which I wish to convey. This is very usually overly forgotten. Ambedkar went on to say, the form of administration, the way we administer, has a close connection with the form of the Constitution, and it is perfectly possible to pervert the Constitution without changing its form, or merely changing the form of administration, and to make it inconsistent, opposed to the spirit of the Constitution. This is exactly what is happening in the country. As someone in the old days said, that he preferred Russian laws enforced with English procedure to English laws with Russian procedure. We can have democracy, or we can have concentration of wealth in the hands of a few. We cannot have both. We can have democracy, or we can have concentration of wealth in the hands of a few. We cannot have both. But the profound observation by Louis Brandeis in relation to India, this cliche comes home with strange poignance. The Universal Declaration of Human Rights of 1948 has made election and democracy synonymous. And democracy with election, human rights and democracy are concomitants, inevitable concomitants, and democracy and elections are concomitants. That's a very interesting but debatable position. The will of the people shall be the basis of authority of the government. Of course, that's the principle of democracy. This will be expressed in periodic and genuine elections, which shall be by universal and equal suffrage, and shall be held by secret vote or by equal and free voting procedure. So, outcome of an election is by definition made equivalent to democracy. But there are certain views which are very interesting, again, to say that this is too sweeping a generalization. Walter Lippmann, in his work called the Phantom Republic, made some profound observations. The justification of majority rule in politics, is not to be found in its ethical superiority. There is no ethical foundation for this assumption. It is to be found in the sheer necessity of finding a place in a civilized society for the force which resides in the weight of numbers. A beautiful thing. This is a compromise made to recognize the weight of numbers and give it a dignified political stature. Elections based on majority rule can be understood as sublimated and denatured civil war, a paper mobilization without physical violence. Look at this. What Lippmann characterizes identification of the functioning of the government with the will of the people as a fiction, as the intricate business of framing laws and of administering them to several hundred public officials is in no sense the act of the voters, nor a transition of their will. Implicit in the idea of a representative democracy are the notion of a filter and a microcosm. In a mass society, it is regarded as not only necessary, but also a positive benefit that the volatile nature of raw public opinion should be refined through an electoral filter that gives representatives the opportunity to deliberate and exercise their judgments, free from the factional interest or majority intolerance. By the same token, a representative democracy has to approximate closely to the society it seeks to represent in order to maintain its legitimacy as system of government. It's a very profound idea. There is a perceptible democratic fatigue all over the world. I call it a democratic fatigue. Various surveys around the world showed considerable increase in calls for a strong leader who does not have to bother with parliament and elections, and that trust in governments and political parties has reached a historical low. This is a pendulum effect, as they call it. You go to the other end, you think the next opposite end is the safe haven. This is the kind of a public mind. And that trust in governments and political parties has reached a historical low. It appears that people like the idea of democracy, but loathe the reality. They love the idea, but loathe the result. Political parties are among the most distrusted institutions in society. But then the idea of a benevolent dictator is a contradiction in terms itself. And there is no substitute for democracy. It is said of Sir Winston Churchill, he said democracy is the worst form of government, except for all other systems we have tried so far. And E.B. White said, it is based on the recurrent suspicion that more than half of the people are right more than half the time. It's a very interesting question that you put. But then the inverse proportion between the vote share, the two systems of, we know that there are two systems of election. One is the first past the post system and the other proportional representation. All others are combinations of the two in some proportions of the other. As to the system of proportional representation, Pandit Nehru, in an interview with Michael Becher, said, I think of nothing more conducive to creating a feeble ministry and a feeble government than this proposal of proportional representation. But imagine in 2014 election, if I remember right, in the 2014 general election, Bahujan Samaj Party got the third largest vote share in the country. But they didn't win even one seat. They got the third largest vote share. Parties which got much lesser vote share had number of seats in parliament. This is an anomaly which is inherent in this system. And ladies and gentlemen, coming to the point of our court at Sentinel, the Qui Vive, constitutional mandate of personal liberty in the early years saw a judicial reluctance to give up to it. There's a very interesting debate. For example, a man was to be detained. If the Home Secretary in England, they said, if the Home Secretary is satisfied that in order to protect public order and public safety, detention is necessary, a person could be detained. That's the famous liver siege case way back in the 1940s, I think 1942, during the wartime. The Home Secretary filed an affidavit, I am in fact satisfied. The majority, the court, court, majority of the court in the House of Lords said, all that law requires is that he must be satisfied. He says he is satisfied. Lord Atkin entered a shattering dissent. He said, subject to satisfaction, all right. The court would seek objective tests of such subjective satisfaction. And Lord Atkin entered a shattering dissent. And aftermath of it was a little strange even in England. Judges, in fact, that judgment of the majority was later on criticized by English jurists themselves. They cynically said it is at best the judge's contribution to war effort. And now we have placed it where it belongs, in the War Museum. Lord Atkin, who entered the dissent in Liverpool, was later celebrated as a great judge. Same thing happened in India in the first case, in the A.K. Gopalan case, the personal liberty case. The Constitution Article 21 says, no person shall be denied life or liberty except in accordance with procedure established by law. Procedure established by law. There are law made for preventive detention. Great 5 judges of the Supreme Court, Justice Fazl Ali dissenting, they said that there is a law. And as long as there is a law, there is no question about deterring and not upholding the detention. They said procedure established by law virtually degenerated itself in the hands of the court to procedure prescribed by the legislature. Is there a difference between procedure established by law on the one side and procedure prescribed by the legislature on the one side? And the judges said, if the law said, they went on to rub the point in by saying, if the law said the clerk of the Bishop of Rochester should be boiled in oil, if the law said that, so be it. The ethical quality of what qualifies to be law was not gone into. And that was the later debate 27 years later in the Supreme Court in the Maneka Gandhi case said that this is not law. First thing is what it takes for a resolution of the legislation to be called law. What are the moral and ethical content of it? And that was the great debate. And that's the starting point. Gopalan was the first embarrassment to the libertarian court. There are 2 cases, ADM Jabalpur and Gopalan, 2 perhaps cases which both of them were overruled promptly. But when they were made, the court took a very dim view of the glory of concept of personal liberty. To rub in the point, the judge said, if the law required that the cook of the Bishop of Rochester be boiled in oil, so be it. This view was overruled 26 years later on. The constitution making in India coincided with the post-war thinking on the need for a universal declaration of human rights. Our fundamental rights discourse was greatly influenced by the post-Second World War contemplations and the need to protect humanity from the scourge of such human conditions. In the development discourse, there are 2 rival theories. One sees economic development as a fierce process which ignores everything, even social interests, which might come in the way. The other theory sees the development process as a more friendly process and sees social reform as the spur and not merely the result of the process. This is a great debate. There is I'm told, a great thesis called the Lee thesis. Lee Kuan Yew, the builder of modern Singapore, he seems to have believed that democracy and development don't go together. If you want development, suppress, no need for overemphasizing democracy. You have democracy, perhaps you may not have development. This is the famous Lee thesis. Virtually after there is a story said about how the committee headed by Eleanor Roosevelt to formulate Universal Declaration of Human Rights. I think India was represented by a lady member, Hansa Mehta. I think it was related to Yuvraj Mehta of Gujarat. That took its own time. And ultimately, on the 10th of December 1948, the Third General Assembly adopted the Universal Declaration of Human Rights. By a felicitous coincidence, exactly 20 years later, on the 10th of December 1968, Professor René Cassin, who was the chief draftsman, the French internationalist, who was the draftsman of the committee, a member of the committee and draftsman, was conferred a Nobel Prize for Peace. Somebody on that occasion asked him, Professor, why does humanity need a universal declaration of human rights? In perhaps the greatest understatement of the century, the professor said, we need a declaration of human rights because men are not always good. Men are not always good could be an epitaph on the grave of the 20th century, where we have killed perhaps 230 million people, 100 and odd million in wars, and the rest in civil strifes, not unconnected with racism, language, linguistic differences, and many differences that separate man from man. And it's also interestingly said that Eleanor Roosevelt, the chairman of that committee, which had to struggle, a lot of opposition discussion, took a long time. She had kept a bottle of champagne to celebrate the signing of the recommendations. It was so delayed that when she opened the bottle of champagne, wine had turned into vinegar. It had gone sour. And she exclaimed that if a bottle of human rights were long, they turn sour. That is the story of the human rights. Ladies and gentlemen, I'll take a little refer to some interesting cases which we have dealt with. I hope after the judicial debacle in Gopalan came the fresh breeze in Maneka. In fact, it is debated in the Maneka case, there was no cause surviving in the Supreme Court at all. The passport had been granted, and there was no list pending in the Supreme Court. Supreme Court took the opposite. There was no fight at all. The government agreed to grant the passport. But even so, the court said, we will not lay down the law. They said, without a cause, you are laying down a law. But that's a different matter. But the content of the judgment is the most relevant thing. After the judicial debacle in Gopalan came the fresh breeze in Maneka. The case of the under-trial prisoners was yet another classic judicial exploration of the great humanism permeating penology. The echoes of Idiga Annamma, she was awarded a death sentence, and the Supreme Court interfered. And the echoes of Idiga, that famous case, was heard in the English courts. Lord Scarman and Lord Brightman in the Privy Council in the case of Noel Rowley versus Attorney General referred to this Indian precedent. Satwant Singh was yet another landmark exercise in the right to free movement. The innovation of public interest litigation was an act of judicial genius. The restriction of the old order on access to courts were removed, and some of the great strides in ameliorative judicial intervention changed the face of the law. Conventional shackles and fetters of formalism were removed. The court developed tools for legal control of government. In a series, in this general, we find a series of cases such as Husainara Khaton, Sunil Batra, Nandini Satpathy, Bombay Hawkers case, Rayappa, Ramana, Vishaka, protection of women in workplaces, and many other socially oriented themes. As to the response of the other common law jurisdictions to the Indian judicial innovation, Andhya Arjuna, a learned lawyer, in an invited article in the Law Quarterly Review says, The beneficial nature of this easy approach to courts, I'm quoting from Mr. Andhyarujana. The beneficial nature of this easy approach to courts by disregarding the conventional requirements of local standard of the applicant and the non-adversarial character of the court's intervention. It became virtually inquisitorial court. Came to be widely appreciated by the public and even imitated by other common law jurisdictions. It was applauded by distinguished judges abroad. Justice Michael Kirby of the High Court of Australia said that the Indian Supreme Court and the High Courts had been particularly creative and imaginative in this kind of jurisprudence. Lord Chief Justice of England and Wales, Lord Wolfe, confessed to having been astounded at first by the provocative approach of the Indian Supreme Court in these and other respects. However, he went on to say, I soon realized that if that court was to perform its essential role in Indian society, it had no option but to adopt the course it did, and I congratulate it for the courage it has shown. Of course, courts have recognized limitations on their power of judicial lawmaking or in the absence of judicially manageable standards or on the grounds of political tickets. Judicial activism can at times run against the doctrine of judicial restraint. Many judicial interventions may not present judicially manageable standards and lack adjudicative disposition. They may answer an urgent human need, but a faint crack develops in the foundations of our system of government. A judge begins to rule where only a legislator can. It is only weak societies that constantly appeal to judicial paternalism to solve its problems. Such a weak society loses the excitement of democracy to fight issues out democratically. That is the hour of a court's temptation. Judicial activism can be a slippery slope. Generally, policy issues are a different and difficult area for judicial penetration. Public policy, Lord Denning once said, is an unruly horse, but it is for a able and competent judge to ride that unruly horse and bring it down on the side of justice. But I don't know how many of our judges are good horsemen at that. But one thing we must understand. Judiciary does not have enough stock of social economic wisdom to say whether the law is wise or otherwise. That's what a great judge exhorted. He said, all that I want is what the crowd wants. American Supreme Court, in dealing with the power under the due process clause, did extraordinarily unpopular things. They struck down paper currency, issue of paper currency, they struck it down. They said you can't issue paper, the gold standard and all that. And when the legislature, the American legislature prescribed working hours for bakery employees who work in oven, before oven set up working hours, they struck it down by saying that it interferes with the freedom of contract. If a person agrees to work for 24 hours a day, well, it's his choice. We can't get into it and interfere with some of these things. In fact, the steel mills are taken over. Millions of dollars are spent on their improvement during World War time. After the war, the court said, give it back to the owners. And there are many, many things which happened. And so much so that ultimately they became the super legislature, the third house, as we call it here, and the super legislature in America. And after the Great Depression, then the New Deal legislation came in. In 1963, officially, in a case called Ferguson versus Krupa, the American Supreme Court said, we are tired of acting the super legislature. We must stop doing that. And they recognized it. They recognized the limitations and then said, And the great Edwin Corwin, a constitutional writer and authority, he introduced a chapter, The Demise of the Due Process, in his book. Instances of monitoring, prosecutions, and investigations in case of corruption, overseeing legislative proceedings, as we have said, whether voting is proper in the fall into a very difficult class of judicial work. Right or wrong, it may serve an immediate purpose, but what it may mean in terms of the balance of powers may be a different argument. In fact, in the appointment of judges case, Lord Robin Cook, who's the House of Lords, was also, I think, Chief Justice in New Zealand. He said something. He said, first article he wrote was where angels were to tread. Of course, the first part, full session, he didn't say, fortunately, where angels were to tread. He said, the majority of the court may have gone too far in commenting on the Indian court, too far, if their conclusions be viewed as an interpretation of the Constitution intended to be binding in law. However, vulnerable in detail, it will surely always be seen as a dramatic event in the international history of jurisprudence. There is an element of sarcasm in this language. Later on, he said, when the angels weep, he wrote an article called Where Angels Weep. He said it sounds more like a promulgation of policy than an exercise in juridical reasoning. Reasoning is noticeably limited. See the language. The reasoning is noticeably limited. All in all, the opinion of the Supreme Court in the third judge's case must be most remarkable ruling ever issued by a Supreme Court, by a Supreme National Appellate Court in the common law world. He expressed his surprise. In the context of such expansive judicial mood, the caution of Justice Harlan Stone of U.S. Supreme Court is worth recalling. I quote, "This court, no less than all other branches of the government, is bound by the Constitution. The Constitution does not confer on the court blanket authority to step into every situation where the political branch might be thought to have fallen short. The stability of this institution ultimately depends not only upon it being alert to keep the other branches of the government within constitutional bounds, but equally upon recognition that the limitation of the court's own functions in the constitutional system." This is another sentinel, the Qui Vive, upon its own limitation. Each branch trying to introspect and find out what are its limitations is a part of the Qui Vive, on the alert. That is also the role of the sentinel of the Qui Vive. A sternal warning of Justice Jackson at the American Supreme Court reads like this: "Doctrine of judicial activism, which justifies easy and constant readiness to set aside decisions of other branches of government, is wholly incompatible with the faith in democracy, and insofar it encourages a belief that judges should be left to correct the result of public indifference itself is a vicious teaching. You can't interfere in the other branches of business unless there's a legal justification." In the USA, the due process clause was used to strike down issues of paper currency, regulating working hours, order and return of steel mills acquired during the war. There are criticisms that the courts have ignored highways and sought bylanes of justice. The courts, however, must not ignore the caution that every judicial decision has to be reasoned out. It has to be arrived at with logical coherence and political neutrality. Ultimately, the court, the American Supreme Court, admitted it was going too far. In Ferguson v. Scoop, it declared that it would no longer act as the super legislature. Another, Edwin Corwin added a chapter called The Demise of the Due Process. Justice Holmes, in his inimitable way, he said, "United States of America will not come to an end if judicial review is taken away." And he is the one who said, "I don't have the stock of social and economic wisdom. All that I want is what the crowd wants. great judge. And ladies and gentlemen, I taken a lot of your time to say some philosophical underpinnings of this thing. In even the human rights itself, in the evolution of political organization of men, there has been a continuous yearning for a higher law as a touchstone for the ethical and moral content of rules of possible law. Parliament can make law, but are there any ethical limits of the lawmaking? Written constitutions are intended to realize this aspiration. It seeks to avoid the concentration of power by built-in checks and balances and constitutes the foundations of the legal system. This is the Sentinel of the Qui Vive. The purpose, I am only exploring the dimensions of this concept of Sentinel of the Qui Vive, is the topic of the talk, by pointing out how this act not only on other institutions, check on other institutions, but check on itself. The purpose of a Bill of Rights is to entrench certain cherished democratic, political, republican values beyond the sway of majoritarian caprice inherent in a democracy. The very purpose of Bill of Rights, said Justice Jackson, was to withdraw certain subjects from the vicissitudes of political controversy, to place them beyond the reach of majorities, and also to establish them as legal principles to be applied by the courts. One's right to life, liberty, and prosperity, and right to free speech, free press, freedom of worship and assembly, and other fundamental rights may not be submitted to vote. They depend on the outcome of no elections. To give them beyond that, because they are the reason is fundamental rights are not conferred rights. Nobody has conferred it upon man, but are inalienable inheritance of man himself. They are above ordinary laws. Ordinary laws cannot change them. They are not built into the law, but are placed above the law. They are not built into the law, but are placed above the law. But then, Bill of Rights is not an automatic assurance of liberty or guarantee of liberty. It depends on the integrity and sensitivity of the institutional mechanism that apply and enforce it. This is the Sentinel of Qui Vive. These rights are not self-executing. They require human agencies for their effectuation. Courts, lawyers, press, and the whole host of governmental agencies are to implement them. This needs the spirit of constitutionalism more than exhortations in the constitutional document. The conduct of political climate and conducive political climate and tradition, and more than all, the spirit of liberty in the hearts of men. If the spirit of liberty is in the hearts of men, nobody can take it away. If it is not in the hearts of men, nobody can confer it. This is the reality. Earlier, there was a sharp divergence of views on a need for a Bill of Rights, whether they should have a Bill of Rights at all, the fundamental rights as we have in the Part 3 of the Constitution. In UK, it was also said that a Bill of Rights would create high expectations in the minds of the people and regarded as a panacea for all grievances, which could not in reality be possible to be satisfied in practice. It is also apprehended that a Bill of Rights might promote an activist judiciary, which might hamper strong and progressive government and result in important public issue being discussed and resolved in legal or constitutional terms rather than in moral or political terms. Lord Denning, a great judge himself and a great exponent of liberty, he wrote a beautiful Hamlin Trust Lectures, Freedom Under the Law is a beautiful document. Lord Denning apprehended if judges were given power to overthrow acts of parliament, they would become political. Their appointments would be based on political grounds, and the reputation of our judiciary would suffer accordingly. One has only to see in the great constitution of the United States of America and India. He said he also criticized the Indian activism of courts. One has only to see the great constitution of the United States of America and of India, the conflicts which arise from time to time between judges and the legislature, I hope we shall not have such conflicts in this country. Lord Scarman, on the other hand, but Lord Scarman, the pillar of the alternative argument, said, when times are normal and fear is not stalking the land, when times are normal and fear is not stalking the land, English law certainly protects freedom of the individual and respects human personality. But when times are abnormally alive with fear and prejudice, the common law is at a disadvantage. It cannot resist the will, however frightened and prejudiced it may be, of Parliament. The classic illustration, of course, is Regulation 18B and Liversidge versus Anderson. Of course, Liversidge was an embarrassment. Its critics said that it is at best judges' contribution to war effort and is now placed where it belongs, in the War Museum. This is the debate. Ladies and gentlemen, I've taken a lot of your time. I thank you for your patience. The reason and science are the twin principles underpinning and driving forces of Western societies. But assertions of sanctity of ownership and property distorted social outlook. That was one of the early debates in India. Rights to and ownership of property became an obstacle for the reforms and social progress because ownership was not accompanied by corresponding obligations. Ownership of property by itself became a fundamental right. A great debate went on. Then Jamindaris was abolished. The first 10 years, the Supreme Court are replete with cases in which the dominance of the fundamental right to ownership. In fact, in Europe, ownership always went as a philosophical concomitant with reciprocal obligations. And the same Bible on which the property rights were conceptualized has two different effects across the Atlantic. In America, it is different. In Europe, it is different. In fact, in the same St. Augustine said, possession of property is a sin unless it's accompanied by reciprocal obligations. I will take a few more minutes to convey what I want to say finally. Rights and ownership of property became an obstacle for reforms and social progress, illustrating how sacrifice of social goals at the altar of rule of law make law itself barren and hollow. Rule of law is only a means to an end, not an end in itself. India's long struggle against entrenched property rights without reciprocal obligations is historic. Initially, the court was a mere precedent-ridden court. It was the second stage at which it became an activist court, developing tools for legal control of government. Supreme Court defended democratic institutions and strictly kept in check misuse of power under Article 356 to supersede governments. The case of State of Rajasthan or the Union of India, SR Bombay, etc. are case in point. In the matter of purity of elections, this is a very important area in which the partnership, you can say, a philosophical partnership between the Election Commission of India under Article 324 of the Constitution and the recognition of the amplitude of its powers by the Supreme Court in a series of cases is very, very important exercise. And that is, again, the great role of the Sentinel, the Qui Vive. In the matter of purity of elections, the contribution of the court is most impressive. In Mohinder Singh Gill case, the court expounded the wide scope of Article 324 and the powers of Election Commission, both express and incidental. In 2019 elections, 43% of the MPs had criminal cases pending against them. They were also told to explain why other individuals without such state could not be found. It was also enjoined that information regarding the selected candidates' criminal record be published in vernacular and national newspapers. There are earlier cases brought up before the court by Association of Democratic Reforms, Lok Prahari, etc. Many significant directions are issued from time to time to protect the purity of the electoral process. By some estimate, not official, money spent by the candidates in the 2019 general elections is estimated around 30,000 crores of rupees. Money power is the biggest enemy of democracy. Money power in elections. In the area of protection of personal liberty, the activism of the court is most impressive. Death penalty was confined to rarest of rare cases. Equally impressive is the expansion of the concept of access to justice. Local adalats are another innovation for speedier justice. The record says they have settled over 80 million disputes, But in judicial lawmaking, as described by Doscoe Pound as juristic chemistry, the court does not make or create the raw material, which are the ingredients of the law. The judge collects the existing raw material and combines or recombines them for the purpose the judge intends to achieve. The court cannot create a new raw material. It's only the political department of government, said a scholar, that has the privilege of considering abstract justice and equity. The raw material can only be created or made by the legislature. Ladies and gentlemen, the increased functions of the state have changed its concept as an instrument of power into an agency of society. The greatest of these concerns that have so far transformed the state, it was increasingly regarded as a proper function or even an obligation of government to ward off distress and strain, not only among the poor, but amongst all citizens of society. The institutional outcome of the assumption by a society of legal and therefore formal and explicit responsibility for the basic well-being of all the members. Such a state emerges when a society or decision-making groups become convinced that the welfare of the individual is too important to be left to custom or to informal arrangements and private understanding, and therefore a concern of the government. But the greatest danger, I conclude with this statement, but the greatest danger to constitutionalism and constitutional government in emergent democracies and developing countries arises from the human factor in public life to distort and vitiate whatever governmental forms may be devised. However carefully the institutional forms may have been constructed, much will turn upon the actual behavior of individuals and their willingness to observe and observe the rules. In a classic analysis of the problem in a book called Constitutionalism in Emergent States, a scholar says, and I quote, "We have seen how political corruption and the waste and inefficiency which it endangers have undermined the ability of the government to secure the welfare of the people, tainting the state in the public eye as an instrument of plunder and thereby alienating the people's loyalty. How tribal politics has, like a canker, eaten into the body politic, sapping its vital energies and the entire fabric of society, pitching tribe against tribe in mutual antagonism, making impossible the development of a national spirit." S.I. Qureshi, former Chief Election Commissioner himself, spoke of the politician-bureaucrat nexus in recovering the investment made in the elections by the candidate. And it says where the corruption, and that is where he says corruption begins. He said elections are polarizing events which have accentuated casteism, communalism, corruption, and crony capitalism. These are the things that he said. Ultimately, underlying it all is the basic legitimacy of the judicial process. The American lawyer said this, and I quote, "The wisdom and moral force of great judges, past and present, make their contribution. Procedural fairness and regularity are also essential to legitimacy. Procedural fairness and regularity are also essential to legitimacy. In the constitutional sphere, law has long drawn strength from traditional and evocative precepts that symbolize the historic struggles for freedom and government of oppression. It is rightly said that history of liberty is the history of procedure. The creative role of the American Supreme Court has been one of great public satisfactions, and it is acclaimed. Speaking of the American Supreme Court, a scholar said, "The final judgment of the American people will unquestionably be that their constitutional rights are safe in the hands of the federal judiciary. Throughout the whole history of the United States, it furnishes the highest example of adequate results of any branch of government. It has averted many a storm, which has threatened our peace and has lent its powerful aid in uniting the whole country in the bonds of justice." It can truly be said of the Indian Supreme Court as well. It is a trusted sentinel of the Qui Vive. Thank you very much for your patience and courtesy. Thank you.
Thank you so much, Justice Venkatachaliah. I would like to ask Mr. T.S. Krishnamurthy if he wants to unmute and come on.
Sir, you're on mute. You'll have to unmute yourself, sir.
Mr. Krishnamurthy, you're...
Krishnamurthy, sir, you're on mute. Sir, you just went on mute again. You had unmuted, but you went on mute again. Now I think you should be able to unmute. Yeah. No, sir, you went on mute again.
I think he always double clicks. So unmute and mute again immediately.
Yeah, this is fine, sir. This is fine, sir.
Is it okay? Yeah.
Yes, sir. We can hear you, sir.
First of all, thank you, Mr. Justice Venkatachaliah, for this remarkable exposition of the subject. I have no doubts that you have done a considerable study and research before you gave this lecture. But I know that even at 91, you are not extinguished as you call yourself. You continue to be a distinguished jurist, distinguished judicial brain. I can see every bit of it in your lecture. We are most thankful to you for a wonderful coverage of the subject. In fact, you refer to the Election Commission and the role of the judgments given by the Supreme Court. I have mentioned in my book and on many other occasions that most of the sensible electoral reforms came only through the judgment of the Supreme Court. And whatever legislative change was brought about, unfortunately, I can confidently say they fall below the expectations of the people. Whatever be so, Supreme Court has played a remarkable role in the conduct of elections. Supreme Court of India has played an important and crucial role in the conduct of elections in this country. And to that extent, I bow my head as a sentinel of our rights of the citizens of this country. Now we move on to the next event to be covered now. We are supposed to have a discussion on the subject by two distinguished persons. First, we have Justice A K Sikri. Respected Sikri Saab retired as the senior most judge of the Supreme Court in India in 2019 and is now an international judge at the Singapore International Commercial Court. He has featured as one of the 50 most influential persons in field of intellectual property across the world. His tenure as the Chief Justice of Punjab and Haryana High Court and at the Supreme Court was marked by several landmark judgments where he upheld the tenets of judiciary and fundamental rights, women's safety, children's rights, and most of all, equality in all respects, in all aspects. In one of his judgment, he has famously said, judges have to be sensitized about securing out speedy justice in cases related to crime against women, elders, children, and discrimination against HIV-infected persons. So judges have been, Justice Sikri and like Justice Venkatachaliah, have all been socially conscious of the need to improve the quality of democracy in this country. We can think of no one better to begin our discussion. May I now request respected Justice Sikri to please share his thoughts on this subject.
Thank you very much. I thank you for giving me this chance to be among this very celebrated and august audience. I start with my respect for the speaker of the day, Justice Venkatachaliah, whom I always fondly call in our judicial fraternity, he is our Bhishma Pitama. And he, in fact, is Bhishma Pitama in so many ways, and he has proved it today also. And Mr. Krishnamurthy, Sucheta Dalal, and all others who are listening to this webinar, which is or lecture, which is organized by you. As you rightly mentioned, Justice Venkatachaliah has in fact covered such a broad spectrum insofar as the subject is concerned, and has taken us not only about the Indian Constitution, ethos, how democracy has to takes its shape, and what is the role of judiciary which comes to, and how it has been performed by the Indian judiciary in last 70 years. But apart from that, he even took us to in a way, showed us the comparative constitutionalism as well as to what has been happening in America and in UK, so other continents also, in the manner in which he covered. It would be very, very difficult to summarize that and say about it within few minutes, which I have been given. But therefore, what I like to do is that I'll be totally, I'll be totally focusing on the subject which is given, that is our judiciary delivering on its role as a sentinel on Qui Vive, which is the in the changing times, so which is the subject which is given. And I think that would be better. But of course, I would like to start from what Justice Venkatachaliah said in his speech. One of the very powerful statement which he made was that civil society should control political society, and office of a citizen. This is he gave every citizen, the office of a citizen is most important. So therefore, it is the citizen which is the fulcrum. It is the citizen which is at the center stage of any democracy. That is, I feel, is the most important message. And if we start from there, and you see how these democracies today, when we are talking of democracies, we have seen from time to time different forms of governance. Be it monarch, it may be dictatorship, it may be any other form of government or governance, but democracy has been accepted now. And as Justice Venkatachaliah also said, that maybe this is not that it is a very, he quoted so many jurists on this and so many political and social thinkers who said that in a democracy, the majority rule, that may not be in a way the best thing, but yes, when compared with the other kinds of systems with which we have seen from time to time, it may be so far the best, or the least worst, if I say so in a negative manner. But it all starts, as I said, from the civilian and the citizens. Now, as we know, and if I talk of the political thinker who was this Thomas Hobbes, who gave us the theory of social contract. He said that, look, in when the men we have come, I mean, from early civilization, when we were savaged and were where the jungle Raj was there, might was right. Everybody who is powerful could kill other person, could rob other person. So therefore, in a society, in such a I mean situation, and human beings, it's a natural tendency that they will always want to want a way out of anarchy. This is very, very important thing, and therefore it is the democracy is founded on what he labeled as a social contract or common welfare, or he gave the name Leviathan state. Now, in a Leviathan state, he said that it is better to give power to one person instead of power with each and every individual and let them govern themselves. Of course, the power, giving power to one person, that one person, like we have seen in monarchy or other dictatorship, then they can be despotic also. But he said that it is still better than having no society which is governed by a particular system. But over a period of time, many other thinkers, they improved upon this the theory of social contract, and particularly Kelsen and Hart, etc., when they said that why this best form could be, to which we come to democratic form, that it need not be the ultimate authority need not be a human being. It can be a set of law or the constitution. That is why today in our modern democracies, without giving the the time with how we traveled from that stage to 200, 300 years, and in today's democracies. But today, what I want to say here is, in a nutshell, that it is not the people, it is not a person, it is the constitution which is the instrument of governance, and it is the constitution which is supreme, even in any constitution, democratic constitution. And that is why, and therefore the power should not be with one. So therefore it is rested with on basically three pillars, that is the legislature, the executive, and the judiciary, and based on which Justice Venkatachaliah also highlighted to great extent on the doctrine of separation of powers and checks and balances. So therefore three wings of the state, they work in tandem, but then their roles are assigned, they work within those parameters which are assigned to them, but then they act as checks and balances on each other's powers also, that whether the every organ is working in a manner which is there, and it is based on, as I said, on the principles which are laid down in the constitution as per the constitution. But again, the important thing which is that in all these things, legislature may make the law, executive has to execute the law, and the judges have to decide. But ultimately, in our constitution also, there is a what we call power of judicial review, which is very, very important. And this power of judicial review which is given, it is not only the judicial review of the executive power, but even the legislative power. So therefore, even an act of a parliament or a state legislature can be, the validity can be challenged and can be tested on the touchstone of the constitutional principles. But then what is important is, in the whole thing, when we come to this kind of governance and the social contract based on social contract theory, is that in every constitution, as again I will say that Justice Venkatachaliah has remarkably covered, that the constitutionality or constitutionalism, which is the attribute of a better governance and a welfare state. And this constitutionalism is, if I, as I say, is or as I see it, is based on two fundamental aspects. On the one hand, we talk that it should be the precepts of any constitutionalism are liberal democracy, human rights, separation of powers, and governed by the rule of law, and which are the essentials of a good governance. And all this talks of, if I may say so, which is very, very important, is that limited government, the concept of limited government. And so therefore, any government which is to act in accordance with the constitution. It cannot take away the fundamental or human rights of the people. And it is based again on the liberty of the individuals, which is to be sorry, which is to be respected. And the three things which, and it is stated in our constitution itself, the three more important aspects are equality, fraternity, and liberty. And around that, and but at the same time, we have our in our constitution part 4 also, which I call positive constitutionalism, and that is based on social welfare, solidarity, economic equality, and social justice, which again Justice Venkatachaliah mentioned, and which we call of as a welfare state. But then the balance of the two has to be maintained. On the one hand, liberties of the people, on the their human rights of the people, they are to be protected, and there cannot be an arbitrary curtailment of that. And on the other hand, welfareism, how we achieve the social justice for all these people. Now, in a democracy, maybe there are, as Justice Venkatachaliah also highlighted, that majority would rule, no doubt, but then there are many pitfalls, or there are many ills of any democratic system also. But the important thing which we are seeing in last, at least in last, we have seen in the history, First World War, Second World War also, when Hitler or Mussolini, who were elected persons, and how they became despotic. So even in a constitutionally elected government may act despotic in a despotic way. This is the very, very important. And in last 15-20 years, what has been happening in so many countries around us. And I would only quote here the message which I want to convey here. This Stephen Letivsky and Daniel Ziblatt, in their book How Democracies Die. This is what is said, and I will read 3 or 4 sentences, and I quote: "Democracies still die, but by different means." But they are comparing it with earlier. It could be a coup, where army coup or any dictatorship who comes and throw away the democracy. He says that may not be happening, but democracies still die, but by a different means. Since the end of the Cold War, most democratic breakdowns have been caused not by generals and soldiers, but by elected government themselves. Like Chavez in Venezuela, elected leaders have subverted democratic institutions in Georgia, Hungary, Nicaragua. He gives so many examples are given. They say many governments' efforts to subvert democracy are legal, in the sense that they are approved by the legislature or accepted by courts. They may even portray it as efforts to improve democracy, making the judiciary more efficient, combating corruption, or cleaning up the electoral process. But it is not seen in the beginning, but over a period of time it is realized. So therefore, in a situation like this, now we have democratic government, elected government. Yes, they have a right to govern, but at the same time, they have also to conform to the constitutional principle or constitutionalism. In the process, individual liberties, rights of minorities, and rights of other marginalized section of the society. That is one thing. And whenever there is some infraction of this, the role of judiciary comes. And that is the topic which we are discussing today. And therefore, what again, I would say what Justice Venkatachaliah has said, and if I paraphrase that the two roles in a democratic system, and which is governed by constitutional democracy, the two important roles of the judiciary are, number one, to protect the constitution and the rule of law. So therefore, any onslaught on the constitution, any onslaught on the freedom of the people, etc., the judiciary has to step in. Of course, ultimately power is with the society, with the civic society, and in the election may take place, and that has been happening in any democracy. If some government is not functioning properly, the people can overthrow. But then during the period, these when a particular government is elected, how to save the constitutional rights, and at the same time how to again bring about the egalitarian society, that becomes the important thing, and therefore it becomes the duty of the any government, sorry, any judiciary or Supreme Court or High Courts in Indian context, to uphold the or to protect the constitution and the rule of law. And the second function is to bridge the gap between the law and the society. I'm not touching upon the second aspect. So therefore, in this context, it is to be seen what is the role which the judiciary has played in last 70 years. And three things which Justice Venkatachaliah, and I'll thereafter I'll stop and we'll see, and whatever the question answers are, then we will answer to that, which have become very important, is that the first, access to justice, then the Indian judiciary in the form of PIL, which it started, then the public law principle, introduction of that public law principles, and with constitutional morality, where he quoted Professor Bakshi and said that judicial leadership, which has been taken as an act of judicial duty, and environmental protection, etc., and making playing a role from adversarial to inquisitorial system in order to advance justice. And on that, judgments which have been quoted by Justice Venkatachaliah from time to time, I need not repeat that. But what I want to say at the end is that, look, Indian Supreme Court or Indian judiciary has seen its ups and downs in last 70 years. We started in the beginning from 1950, say, to 1973, 1974, when judiciary was acted a little in a conservative manner during that period. Then came the emergency, where ADM Jabalpur was one judgment which is always seen as one of the black spot in the Indian judiciary, which fortunately stands overruled now. But then after the emergency, total transformation came. And it was not only transformation in the Indian judiciary, but constitution was also a transformative constitutionalism. All those factors were brought with the kind of judicial activism with which the judiciary worked, and the principles which, as I said, PALs and role as a public law principle introduction and adversarial to inquisitorial, what Justice Venkatachaliah has said and has given all those judgments. Now the question is whether it is continued and it is sustained. We know of late there is again some criticism of the Supreme Court for whatever for so many reasons. There are some issues which have I'll only flag those issues which have been raised, that all that is whether, okay, even today the court is protecting the rights of the people, but whether it is doing it selectively. Now, and other thing is power of the contempt which is used by the court, whether it is justified. Role of the role of the Chief Justice of India as master of the roster, whether it is being this role is being discharged in an objective manner, or there is some criticism to that, and whether the Supreme Court or the other courts are acting selectively by not taking some of the issues which are very, very important and sidelining or playing the role of a procrastinating institution, not giving them the priority, but giving priority to other cases. So therefore, these may be the things. But if I may say at the end, and of course thereafter, whenever there are question answer session, we will reply to that. That maybe, you see, at the end of the day, it may be that PIL or over activism, which judiciary indulge into, which Justice Venkatachaliah also said, maybe is an invitation for all this kind of criticism. Because with this, although it has done wonders for the welfare of the people in this country, no doubt about it, but then enlarging the scope of PILs only from marginalized section of the society for the poor and illiterate and access to justice by broadening the this locus standi rule, with which it started, and going to the and intervening in every kind of political matter or policy decisions also, by and in the process becoming over activism, whether because with this the expectations of society has also gone high. Now it is not, the judiciary cannot act as a catalyst. Ultimately change in the society, if it has to come, it has to come from other sources. It is not that it is the role of the judiciary. So what kind of role judiciary should play, and whether it is, it's because now in spite of so many judgments even now coming, which are really wonderful judgments, at the same time there are some section of the society which will look into only those aspects of the judiciary and will criticize where it has not been able to perform the role, that too according to them. So that is here, and some of the issues which I have highlighted, I think the system has to be devised how to prioritize the case. It should not remain that kind of opaque system which is perceived when the criticism comes. So on the whole, my conclusion is the judiciary has been able to play that role over a period of time. If we see all that 70 years role as a sentinel on Qui Vive, on which I entirely agree with my Honorable Chief Justice, our Bhishma Pitama, but at the same time, some introspection is needed how to go forward. Thank you very much.
Thank you so much, Justice Sikri. That was such a wonderful summation, and I'm so glad that you tackled so many issues upfront and directly. Mr. Krishnamurthy, would you come in, please?
Sir, you'll have to unmute your unmute the thing, sir. Now, if yeah, now we can hear you, sir.
Yeah, is Indira Jaising here?
Yes, sir. Yes, sir.
Yeah, I think I don't see her photograph on the
Ma'am is here, sir.
screen. Okay, now I have a great pleasure in introducing Indira Jaising, our second esteemed member of the panel. Ms. Indira Jaising is a renowned advocate and human rights activist who was the first woman to be appointed as Additional Solicitor General of India. I have known her when I was in Delhi, participated in some meetings, a Padma Shri awardee. Ms. Jaising ranked 20th in the list of 50 great leaders of the world by Fortune magazine in 2018. Along with her husband Anand Grover, she co-founded the Lawyers Collective, an NGO devoted to feminist and left-wing causes. A huge champion of women's rights and human rights, she has argued several cases relating to discrimination against women, sexual harassment cases, and has also represented the victims of the Bhopal tragedy in the Supreme Court of India. With over 50 years of experience in the Indian judiciary, we are happy to have her and to have her views on the subject.
Before I make my comments on the topic for today's lecture, I would like to make a few relevant comments about the work of former Chief Justice M.N. Venkatachaliah, who has delivered your keynote address today. Whether the judiciary delivers on its promise or not depends on the people who get appointed as judges. Who makes these appointments? It was during the period of his tenure as former CJI that the Supreme Court made a tectonic shift from judges being appointed primarily by the President of India with the aid and advice of the Council of Ministers to judges being appointed by the judiciary in consultation with the Prime Minister, no doubt. This happened 12 years after a bench of 7 judges of the Supreme Court had decided in the S.P. Gupta case that the executive would have unlimited powers to appoint judges. Justice Venkatachaliah therefore played a very important role in the development of the journey of appointment of judges. Although he was not a part of that bench, it fell upon his shoulders to make appointments of judges. Many years later, the Supreme Court decided that not just the Chief Justice alone, but a collegium of the Chief, together with the 4 senior-most judges, would make appointments to judges of the Supreme Court, and 3 senior-most judges would make appointments to the high courts. To Justice Venkatachaliah's credit, he made transfers of no less than 50 judges to different high courts on the ground that they had their own relatives practicing in those courts. It was perhaps the first attempt to get rid of dynasty and nepotism in the judiciary. He chaired, of course, as we all know, the Constitution Review Committee, made a suggestion that appointments should be made by the Chief Justice for 2 senior-most judges of the court and the law minister and an outside jurist. This suggestion was not accepted. Many years later, the Judicial Appointments Commission Act was passed, in which once again the executive took primacy in the matter of appointments. We know that this was struck down by the Supreme Court, returning the power of appointment back to the collegium. But now we need to address the most critical question: has the judiciary delivered on its promise? Has it acted as the arbiter between the rights of the citizen and the executive, which is exactly what Justice Venkatachaliah's speech tells us is the true role of the judiciary under. An even more fundamental question is, how do judges get appointed at all? From your 3 speakers today, the keynote speaker, Justice Venkatachaliah, Justice Sikri, and me, I am the only one who is a practicing lawyer. And I would choose, therefore, to speak from the point of view of a practicing lawyer. This requires me to go through a very brief history of the legal profession in India. We know that lawyers played a very prominent role in the pre-independence movement. They were deeply engaged with the freedom struggle, and they became what we will describe as the transitional lawyers, those who straddled the world of pre-independence and post-independence. They came to be appointed as attorney generals and solicitor generals. I cannot help commenting that they were well versed in colonial laws and the common laws, but they were only beginners in a regime which guaranteed fundamental rights. We then come to a generation of lawyers who were supported by business houses, whose main challenges were challenges to progressive land reform laws, to nationalization, and also to liberty. These were lawyers who were supported by business houses. For example, Mr. Palkiwala was one of them. Those who served the interests of big business and industry and provided them with a platform. They experimented with challenging laws on the ground that they violated fundamental rights. But as Justice Venkatachaliah himself points out, they failed miserably when it came to the right to liberty. In the case of A.K. Gopalan, it was held that once due process of law is complied with, the reasonableness of the law need not be looked into. I'd like to give now a sociological account of the bar in India since then. The Bombay bar appears to have dominated developments in the country, including in the Supreme Court. They were drawn mainly from among Parsis and Gujaratis. The Calcutta bar was dominated by Bhadraloks, irrespective of the caste and creed to which they belong. The Madras bar was dominated by Tamil Brahmins and the Tram Brahms in pre-independence days. In the post-independence period, the character of the Madras bar appears to have changed in the matter of confronting social justice issues. It is this generation of lawyers who could have been role models for the future of the legal profession in this country. And the reason I go into this is because this is the pool of talent from which we draw our judges. In my opinion, this generation can be characterized as what I call the lumpet generation of lawyers, overly deferential to power and authority, and willing to accept whatever came their way. I will now move on to my own generation of lawyers. I call myself one of Midnight's children. deeply influenced by the ideas and values of the freedom struggle. But what was the freedom struggle? Justice D.Y. Chandrachud describes it eloquently in Indian Young Lawyers Association as follows. Reading Dr. Ambedkar compels us to look at the other side of independence movement. Besides the struggle for independence from the British rule, there was another struggle going on for centuries. And this was the struggle for social emancipation. It has been the struggle for independence of an unequal social order. It has been the fight for undoing of historical injustices and for righting fundamental wrongs with fundamental rights. The Constitution of India is the end product of both these struggles. It is the foundational document, which is the text and spirit, aims at social transformation, namely the creation and the preservation of an equal social order. The Constitution represents the aspirations of those who were denied the basic ingredients of a dignified existence, close quotes. It is this approach that has guided my own lawyering over the last 50 years. There is no doubt that the journey in law was inspired by, as Justice Venkatachaliah points out, by public interest litigation developed by judges like Bhagwati and Krishna Iyer. Without them, our efforts would have been as nothing. He has referred to two of the cases which I argued, the Olga Tellis case for the rights of pavement dwellers and the Bombay Hawkers case for the rights of hawkers, both of which dealt with the right to livelihood and dignity. These were cases which brought to court the concerns of the disinherited of the earth, hawkers, feriwalas, homeless, the rights of the self-employed, vegetable vendors, the rights of tribals and nomads, and the rights of women to hawk on the streets of Ahmedabad through Seva. Subsequent developments in PIL jurisdiction must be left for another day. We are yet to conclude what is the impact of opening the doors to anyone. Now one single resident of Delhi can file a PIL questioning a whole movement of farmers on the ground that he is, quote unquote, a taxpayer, and hence has the locus to stop a protest of a whole community. Individual rights have the potential to defeat collective rights, a very dangerous precedent. I say no more, except that the voice of a generation of tax lawyers, a generation which sees its own individual convenience over all else. Way back in 1984, when I was arguing the Olga Tellis case, we were told that pavement dwellers are, quote unquote, a nuisance and need to be removed from the, just like boxes and benches need to be removed from the pavements of Municipal Corporation of Bombay. Mind you, this is all recorded in the judgment. For those of you who care to read it, you will see that the argument of the Bombay Municipal Corporation was that the pavement dwellers are a nuisance. They were not called the homeless, they were called a nuisance. We then move on to the era of the national law schools. These lawyers who came out of national law schools were ideally suited to a neoliberal politics, to structural adjustment, and to the demands of a globalized economy. They entered the comfort zones of the hallowed law firms, giving a go-by to litigation. Regulatory agencies assumed importance. Electricity, infrastructure, and internet were the new havens for lawyers. Surprisingly, anti-competition law did not find the place that it should have. Finally, recent developments have seen young lawyers come to the aid of those who have been arrested in the Delhi riots, of people on social media who are being told that they are disrupting communal harmony, of lawyers who are fighting so-called conspiracies in every nook and corner. This gives hope for the future. If the 20th century bar in India was an anglicized bar influenced by Oxbridge alumni and barristers, the bar of the 21st century in India appears to be mainly Americanized, with ideas brought home by LLM doctorates from the alumni of Ivy League universities such as Harvard, Pennsylvania, and Columbia. But coming back to the issue at hand, this is the pool of talent from which we draw our judges. And while making appointments, we must be conscious as to what is the ideology of the person we are appointing. This, of course, brings me to what I have called the ideological court. Some have called it the executive court. The evidence is on the table. From the decision in Babri Masjid to the decision to put in cold storage CAA, electoral bonds, a challenge to abolition of 370, from the grant of bail to some journalists and not to others, we see evidence of a highly self-conscious court. But perhaps this is a charitable description. What we really have is more than one Supreme Court of India, and sometimes more than one person in the personality of one judge. A pick and choose policy is what we see, perhaps the power vesting with the master of the roster. A majoritarian government brings with it its own perils, as pointed out by Justice Venkatachaliah himself. Well, can we say that it succumbs, that the judiciary succumbs to a majoritarian government? Are we seeing a threatened judiciary? Are we seeing a repeat of ADM Jabalpur, where one of the judges said, I have a diamond hard hope that the state will treat its children in detention, its citizens in detention as its own children. Now, back to appointment of judges. In the United States, at least, we have the benefit of transparency, where every judge prior to appointment is questioned on their attitude to the issues of our times, abortion, the wall of separation between religion and state, and the rights of the LGBT community. In India, we have the worst of both worlds. We do not have that kind of transparency. And yet we know that a consensus which is built between the judiciary and the executive does have the last word. I propose instead an equal opportunities manner of appointment of judges. I propose that applications be invited for the appointment of judges from interested people, putting on record their biodata. This, I suggest, will ensure that women's, Dalits, LGBT community will all have an equal opportunity to get appointed as judges, and the judiciary will reflect the issues of this very diverse nation, diversity in terms of religion, language, and culture. We are now in a post-COVID world. Not surprisingly, the pandemic has made the rich richer and the poor poorer. Our challenges are many. Our primary challenge today is our food security, which is thought to be dismantled through a threat to the supply chain being monopolized by big business. These are the challenges which will find their way into the judiciary sooner, if not later. And I'd like to end by saying that we in this country should be prepared to appoint the best possible people, men and women, for the job of sitting on our Supreme Courts and our High Courts, and indeed all our other courts. Thank you very much.
Your discussion now.
Yes.
Sucheta Dalal, I think, shall we invite Justice Venkatachaliah's comments, concluding comments, and then do you have time for question and answers?
Yes, absolutely. I think Justice Venkatachaliah first.
May I request Justice Venkatachaliah to give his closing comments? So only one point I thought the number of people have mentioned is about expensive justice and then the lower judiciary reforms, etc. Of course, I don't know whether we'll be able to cover all this in the session, but if you have your views on this, people will be happy to hear you.
Mr. Krishnamurthy, this talk was confined to the role of the Supreme Court as the sentinel of the Qui Vive. But you have provoked me to say something about the judicial system itself. I think we could perhaps have mismanaged our affairs better. And the kind of technological developments all over the world, sooner or later, we have got to sit down and analyze the trial system and the subordinate courts and the work culture of the courts. Possibly there's a recent writing by a scholar by name Richard Susskind. He said, online courts, future of justice. Now the work in the tribunals in England, most of it is online. And the court management, case flow management is so excellent that at one point of time, from the magistrate or the trial court to the House of Lords, it takes 7 years. Now it has been brought down to 3.5 years. It is possible in India that if you plan it properly, exploit the technological development that have occurred, and perhaps the introduction of artificial intelligence. Perhaps if you manage it better, I think in about have some 3 years' time, put it on an assembly line, 90% of the cases can be disposed of in 18 months. And in the first 3 years, in the next 3 years, 95% of the cases can be disposed of within 12 months. Of course, 5% of the cases are sticky business. They will take their own time. You can't prescribe a time schedule for all cases uniformly. Possibly some 5% of the cases remain that way. The interesting thing is, out of the 35 million cases pending in the subordinate courts, 50% of them are in 5 states. Just 50% of them are in 5 states. And if you set up one district as a stereotype mechanism to handle the case flow management, possibly things can be solved. I think people are now applying their minds to the potential of the new scientific developments and the communication systems. And possibly, I expect, out of sheer pressure of the public opinion, within a year's time, a model will come out. And I'm quite sure that the trial system will be revolutionized if some of the potential of technology is harnessed and utilized. Work is going on, and it's a very interesting book. Almost the tribunals in England are virtually 70 to 80% of the work is online. It's a very interesting thing, and there is a great potential of technological exploits in their application to judicial system, particularly in the trial stage.
So thank you very much, sir. And Sucheta, would you like to take 1 or 2 questions, or depending upon, yeah.
Yes, so we have a galaxy in the audience, and I think, we'll take just a couple because it's been a long session. So, Arvind, you want to?
Hi, ma'am. Can you hear me?
Yeah.
So, ma'am, we have received a question. Actually, Shailesh Gandhi sir has also shared a question of his. So I'll just go ahead and share that.
No, let's
Hello? Yes, ma'am. So I was just going to request if he could also unmute. Gandhi sir, can you please unmute? So we can hear you, sir. You left. Hello.
The question, sir, is there are 2 kinds of positions Supreme Court takes. At times, people say the court makes the law. At times, it is said the Constitution guides. My simple question is, if the Parliament makes the law, in my opinion, it can be struck down on the basis of not being in consonance with the Constitution. But short of that, is it okay for the Supreme Court to give its own meaning to laws which was never intended by the legislature or the words of the law?
May I request Justice to...
What is the question? May I understand the thrust of the question? Mr. Shailesh, would you like to
repeat
Yes,
or
sir.
summarize the question, please?
Yes, sir. In simple terms, lawmaking, in my understanding, is the job of the parliament. And it's the Supreme Court's job to interpret it if there is a difference in words. But I think number of times, though the law is very clear, the Supreme Court says we make the law and therefore what we say is the law. Is this right?
Yes. Thank you for this. Thank you for your question. This is an old question which is being raised every time when a judicial exploit in terms of serious decision is undertaken by the court. Normally, judicial work is about a pending dispute, a dispute that already exists. For example, there is a statute. The rights and liabilities of the parties concerned in the administration of that statute already exist. Therefore, that is a judicial duty to resolve any dispute that arises under a statute. But in a constitution, it is not what exists, what might come up in future. And any decision of constitutional interpretation is not mere adjudication. It has an essential legislative element in it. And that is what is called the judgment law. Then somebody said, how can judge make a law? But when in a precedent-ridden court, for example, the judgment that is rendered today will be binding on the subsequent cases in the High Courts and the Supreme Court itself, unless it is overruled. And that itself is, the judicial process itself inevitably involves a legislative element. That is what's called the judgment law. And it is inevitable. And this question was put to Lord Reed. He said, we don't believe in fairy tales anymore. Judges do make law. Because in the very legislative process, the judicial process itself, the moment you decide, that becomes a precedent in the next case. And in Constitution, the judgments that you render are not deciding a pending single dispute. It is a matter concerning the future. Therefore, essentially, that is the sense in which law is made by the court through its decisions. This is my understanding of it.
Thank you very much, sir. Arvind, any more question?
Yes, sir. There is one question that we've received from a student, Ms. Poonam. This question is, judicial activism sometimes is criticized by calling it judicial outreach. Hence, her question is this: if in a large democracy like India, the provision of separation of power between different organs of the state legislature and the judiciary, is it practically workable?
Please tell me what's the ultimate formulation of your question?
So the question is in a large democracy like India, is it possible to separate the different powers of organizations like the legislature and the judiciary? Is it practically a workable solution?
Thank you for the question. This is the essence of the subject matter of today's debate, namely, is the Supreme Court a sentinel of the Qui Vive? That is, to protect the rights of other departments of government, of the state, executive. We must know when judges begin, the old English statement was, the British will not tolerate to be administered by the judges as they don't tolerate to be legislated by the executive. The essence of the difference is that the purpose of judicial adjudication is not merely to exercise judicial power, but also to see that other departments of the state, namely the legislature and the executive, function within their bounds. Therefore, the work of the Constitutional Court is to reconcile the possible conflict between legislature and the executive, executive and the judiciary, legislature and the judiciary. Therefore, this is a court which has to consider the constitutional provision. It is not merely interpreting it, it is expounding it. It is called expounding the Constitution, because any judgment of the court explaining the scope and the import of a constitutional provision has an effect on other departments. The essential thing is the coordination will come in when a fundamental right and its dimensions are expounded by the Supreme Court, law is laid down. Then systems must be built in by the executive and the legislature. Incidental supporting legislation may be necessary. And all this kind of thing is a matter of coordination, which has at the heart of it the effectuation of the guarantees of the people, guarantees the Constitution gives to the people. Therefore, it is a kind of a coordinated effort. Supposing the court goes beyond the constitutional limits, the legislature can overrule the judgment. It can pass a legislation. We have any number of instances in India where the Supreme Court judgments have been overruled by legislative overruling of the judicial judgment by amending the Constitution if necessary, or amending the law if necessary. And this is the balance that is, that's how a constitution must be worked. It is expounding a constitution. It is not interpreting a provision in the constitution for the time being. It is a process by which the whole the system grows up in coordination. That's how it works, and that's how all the experiments of all democratic constitutions. Of course, England doesn't have a constitution excepting the Human Rights Act, where you can't strike down a law. In fact, it used to be said that as students 70 years ago, we would be hearing the first proposition of the supremacy of the British Parliament. If the British Parliament said all blue-eyed children should be drowned in Thames, that's a good law. Nobody can interfere it. But even there, the question arose in early part of the 17th century, I think 1603, in a famous case called Dr. Bonham's case. If the legislation runs against the justice of the common law, the court can strike it down. That is how they construed it. And this is a work of the genius of the judges and the willingness of the administration to understand the import of the judgment, and the willingness of the alertness of the legislature. If it finds that the court has exceeded its limits, it can use its legislative power to bring it in line. This is a matter of constructive approach to the working of the Constitution by all the agencies responsible for the working of the Constitution.
I think we have plenty of questions, but I don't think we have the time. I wonder whether we should conclude the meeting. There are questions like, judicial appointment, and questions like contempt of court and so on.
You can permit, in your discretion, one or two questions, sir.
Yeah. Mr. Arvind, can you just select?
Actually, I wanted to hand it over to ma'am, because ma'am had
sir,
mentioned that.
can we ask Justice Sikri and Indira Jaising to respond to this, maybe, before we close? Mr. Krishnamurthy?
Yeah. In fact, no. Are you going to take questions, or are you asking for their comments?
I think they are also looking at the chat, so I would like their closing comments from both of them.
There are a number of questions, both addressed to Justice Sikri and Madam Indira Jaising. And I don't know whether you have had a look at those questions, but if you have any closing comments, maybe you can give them so that we can proceed further. First, Justice Sikri, if you have any comments, sir.
Oh, so I think he's dropped off the call.
Okay. Can I request Madam Indira Jaising to give her closing comments?
I think it's very interesting that on this panel, we have straddled three generations. From the generation of Justice Venkatachaliah to my generation, and then to Justice Sikri's generation. So I think the points of view that we have seen represent virtually the history of 70 years of functioning of the judiciary. And so the only really closing comment that I'd like to make is that we should not be judgmental about anything for that matter. We should look at things in a historical context. And we all know that history must be studied in order that it's not repeated. At least the faults of history are not repeated. And it has always been a very great pleasure for me to have appeared before Justice Venkatachaliah in court. I have argued extremely important cases in his court, including the Bhopal tragedy, and I'm deeply aware of his learning, which I think is a national treasure for all of us. But I'm happy that despite the fact that we belong to so many different generations, we've been able to converse with each other in a very dignified manner. Thank you.
Thank you very much. Thank you. Now, may I don't think there is any other important question. Mr. Arvind, would like to take it, or we can go for the vote of thanks?
I can hand it over to ma'am, sir, actually.
Any other question? Cheta?
We are way beyond our time. So,
Yeah.
much as I would like us to have a lot of questions, I think we need to close.
Yeah.
So
may I request Devshish Basu to propose a vote of thanks for this extremely important and useful session. It's very unfortunate that we have limitation of time. There are a number of leading persons, legal luminaries asking for questions. It's unfortunate that we are not able to take these questions and extend the session. So I request Mr. Devshish Basu to go ahead with the vote of thanks.
I'm sorry, I'm going to step in for Devashish this time.
Okay.
I'm proposing the vote of thanks. With this, we come to the end of the third RTI annual lecture. The comments show that this has been an extraordinarily enlightening couple of hours. We're deeply grateful to Justice M. Venkatachaliah for his words of wisdom. He has shown once again why he is called the Bhishma Pitama of the Indian judiciary. Sir, we are especially enthused at your prediction that technology can end judicial pendency to a great extent in 18 months. In saying this, far from being extinguished, you have shown that you're way ahead of many who are on the bench today. We, the ordinary citizens, are most concerned about the turmoil in the judiciary and the system of justice. So I'm deeply grateful that both Justice A K Sikri and Madam Indira Jaising did not hesitate to address many of the concerns that all of us had and took them head on and addressed them. There were a lot of expectations from today's program. This is evident from the extremely distinguished audience we had today. We have had among us today senior and very respected judges, respected bureaucrats, activists across the spectrum, lawyers, doctors, concerned citizens, even Super Cub, Mr. Julio Ribeiro. And we couldn't have done better than having Mr. Krishnamurthy, who's been such a role model for all of us, to preside on this event. I end today's evening with a special thanks to Dinesh Thakur and the Thakur Foundation for having made this program possible. Thank you all for attending, and good night.
Thank you very much. Thank you, sir. Thank you.
Thank you. Good